In circumstances where an application has been flagged by IP Australia as not meeting the requirements of the Act, an examination report will be provided to you as the applicant, outlining any issues IP Australia has identified. Possible issues may involve a lack of distinctiveness of the trademark or similarities between the client's trademark or earlier registrations and applications. You may be required to provide evidence as to the description or function of the goods or services, and you may need to amend the application for registration. The amount and kind of evidence required to achieve acceptance will depend on the issues the examiner has raised in their report. However, there are two common grounds for rejection, that being Sections 44 and Section 41 of the Trademarks Act. The amount and kind of evidence to achieve acceptance will depend on what issues the examiner has raised in their report. However, there are two common grounds for rejection, that being under Section 44 and Section 41 of the Trademarks Act 1995, to which you may need to provide evidence demonstrating your goods or services comply. Let's take a look at each of these sections now. Under Section 41, the evidence should demonstrate that you have promoted it and used it to such an extent before the date of filing that consumers view it as an indicator of trade source, or that you have promoted it and used it to such an extent that consumers view it as an indicator of trade source rather than as a description of goods and services. In any circumstance, IP Australia will often do their best to assist in overcoming objections to acceptance.